All right, there we go. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of Wills and Advanced Legal Planning, Part 2, and how to draft your own will and transfer on death deed, or TODD, as it's commonly known as. My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods. And I want to give a quick shout out to Miss Cecile Carlson, who's typically joining us today, but she's a bit under the weather, so we're wishing her a speedy recovery. In addition to that, we have Ms. Jessie Campbell representing Lone Star Legal Aid, who's going to be presenting the information for you all today. We also have the Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, the Earl Carl Institute, Houston Volunteer Lawyers, and Texas Legal Services Center, who are all, and we all make up A Month of Service. And just to give you a quick little history, A Month of Service is a collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information to the community relative to asset protection, the maintaining of generational wealth, asset building, and community empowerment. Several years ago, we decided to collaborate and come together and pool a lot of our initiatives and workshops together in an effort to create a larger impact to reach more people, considering that we pretty much all service and serve the same community. We know that there are a lot of underserved communities that are out there that don't have access to a lot of information, that don't know where to go for valuable resources and for assistance. So we decided, oh, why not? Let's do this and reach more people. This platform that we're on now via Zoom, which we had to convert to due to the pandemic, it has allowed us the opportunity to reach people outside of the city of Houston, Harris County, surrounding counties, and across the entire state of Texas, in some instances across the country, where people actually tune into our workshops and receive the information that we have to provide. Do note that regardless of where in the state that you're joining us from, information that is presented here is relative to the entire state of Texas. It is not just for the city of Houston or Harris County, but it is law there. The laws that and information that she's going to go over is relative to the entire state. So just know that. I know that there's sometimes, you see these things out on social media where they talk about wills and, trust and things like that, but they're not relative to probate and estate planning laws for the state of Texas. So keep that in mind as you're out there kind of doing some research and listening to things on social media. Know that what you make sure or ensure that what you're doing or what you're putting in place, that it's relative to this state. And then Ms. Campbell's also going to go over that kind of stuff too. Also note that information that does get provided here today is for educational purposes only. It is not to be considered legal advice. However, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid, the Earl Carl Institute, and to Houston Volunteer Lawyers if you find yourselves in need of any civil legal assistance and need any help with drafting your will and other documents. And Ms. Campbell's going to go over information, other services that are available through Lone Star Legal Aid as well. With that being said, this is your opportunity to ask questions that you have. We do ask that you try to keep your questions to be as general as you possibly can and not to divulge any personal detail information, as we are on a public platform. We do record the session as well as broadcast live on our social media pages. So we want to try to protect your privacy as best we can and not try to divulge any personal detailed information out here. This is not the setting to ask, real specific questions, but try to formulate your question to be as general as you possibly can. If you're joining us on Zoom, you have the opportunity to type your question into the chat or wait until the end and you can unmute yourself and ask the question directly of the presenter. If you are joining us on social media, I am monitoring the comment section, so you can type your question into the comment section and I'll make sure that it is read aloud at the end as well. So so everybody will have an opportunity to get their questions addressed. And Jesse is really good also about when you type your questions into the chat to kind of incorporate the answers to those questions as you're typing them into the presentation as she's going. So There's a lot of information that's going to be covered here today. We do hope that you all receive the information that was intended for you to receive by you coming here. You can come back as often as you like. We do these presentate this specific the Wills in Advanced Legal Planning presentation is scheduled for the first Thursday of each month. However, it is divided into two parts, and we're going to kind of get into that part as well. But again, thank you all for joining us. And we want to welcome you. For those that have come back and continue to support a month of service, thank you very much for your participation and for helping us to get the word out to other people that do also find this information to be beneficial. If you're joining us for the first time, we want to welcome you and thank you for joining us and being here today. So without further ado, we're going to go ahead and get started, have Ms. Jessie introduce herself and move right on into our presentation. So Jessie, you're on mute.
Yeah, so I was like, first, let me unmute. Good afternoon, everyone. Give me 1 second to go ahead and get my slides onto the screen, and we'll get going. My name is Jessie Campbell. I am a directing attorney with Lone Star Legal Aid, and we are here to I'm just getting me set up. Sorry. It's hard to talk and move slides around.
You're
But
okay.
today we're going to be doing part 2 of our estate planning presentations and for today, it's going to be discussing how to draft your own will and a transfer on death deed. For those of you who have not seen part 1, I do recommend that when you have an opportunity, it is available on our YouTube page, as Ms. Nia just mentioned. And because on that one, we go over kind of a big picture things. I explain what all the documents are and what they do and why you would need them and things you need to be thinking about when drafting your own documents. Whereas today, as being part 2, it's really for those individuals who want to choose to try to draft their own documents as opposed to either applying for services or hiring an attorney. So let's get going. All right. So a little bit more about Lone Star Legal Aid. We are a legal aid service provider. We handle civil legal needs, and that is a wide range of topics that you see on your screen there. That includes consumer, employment, family, healthcare, housing, landlord-tenant, public education, benefits, estate planning, and probate. And so we cover a lot of things. Things that we don't do are like traffic tickets, criminal matters. We don't handle criminal matters except for record clearing and things that are like personal injury cases. So, but for the most part, when you're talking about everyday kind of legal matters that people will encounter, we typically may be able to assist on those. We serve 72 counties in the eastern and Gulf Coast region of Texas and 4 counties in southwest Arkansas. So pretty much from the border with Louisiana up to as far west as Waco, and then from Galveston to Texarkana is where we are with 14 offices. Our headquarters are in Houston, which is where I am located. But you can see the list of our offices throughout our service area. We are a legal aid provider, which means that you are eligible based on income and assets. I wish I can tell you it's a simple mathematical thing, but it's not. It is a little bit more complex than just me being able to say, this is how much you need to make based on your household size, and you're definitely eligible. So, but it is based on that. No, typically what I say is that about a fourth of the state is eligible for services, depending on different factors. And so don't necessarily assume that you don't qualify for services, because sometimes you may be surprised in that. As we go through today, I will remind everyone that it is for educational purposes only. I am not here to answer any legal questions that you may have in the sense of what is applicable in your own individual situation. As Ms. Nia already mentioned, this is a public space. When you are asking questions or typing it into the chat or in the comment box, remember, the internet's forever, so we don't want to have any kind of private information that for any potential bad actors to get access to and do something that you don't want. And but also I'm not allowed to. I'm not your lawyer today, and so because I am not your lawyer, I cannot provide you with legal advice as a general rule. But you may find that this can be a bit overwhelming. There's a lot of information. And again, if you do need assistance, that's how you can reach me. We also have the other partners, and then we also have some other resources if you are able to afford an attorney on how you can find one. And I'll talk about that towards the end. Okay. Um, so today we're going to be spending the majority of the time talking about how to draft a will, which you will see here. But first, we're going to talk a little bit about choosing your representative. This will be a little repetitive for those of you who did attend part one or have already watched part one. But it's important when you're doing this document that we understand what the representative is doing. Then we're going to spend most of our time talking about how to draft your own will. Then transfer on death deed, and then finally our last bit of advanced planning documents. As you see, that is the information there on how you can find us, and on YouTube, and our profile name is at Amos Houston 7469. All right, so let's get going into this topic. All right, so choosing your representative for each document that you have, and then today we're going to be talking about the will, but this includes the other documents. You're naming a person. You're naming a person to step into your shoes to kind of take care of business, is really kind of what it is, right? It's a person that is going to be handling all of the affairs as it relates to probating an estate after a person passes away, in terms of choosing your executor. And so it really needs to be someone that you know and trust and who will do what's in your best interest, or as you would do in this situation when there's questions that can kind of come up. We highly, highly recommend that you select just one person and no shared authority. It doesn't mean that you can't do it, but the reason why attorneys don't recommend it as a general rule is because you can have conflicts. One of the reasons why we draft these documents and have them in place is so that we can provide instructions on what we want to happen with our property, how we want to have our estate handle, our medical decision making, and and so when you have a situation where you have two people, you can have some conflict, right? So you all of these best intentions of how you draft your documents, but then two people can come and play, and they may disagree on how they want to approach a question that was not specifically provided for in the document. And then who's now going to be in charge? Now we have conflicts in this potential court action that may need to be taken. And it can cause some stalemates. And so we don't recommend having two. And one of the ways I heard about it in my own training on these topics that I thought made perfect sense when they said it was that, do you really want two people driving a car? And you really wouldn't want that, right? And so that's kind of the analogy to kind of think about. As you pick the individual to do it, you want to discuss that decision with that person. They don't want to be caught off guard, right? Like, don't surprise, you're the executor. That's not really a good place to be, because one, you have to be sure they want to do it, that they are capable of doing it. And then also that they understand what the work is, what's being asked of them, and then empowering them, having conversations with them about your decisions, what you wrote in your document, what you would do in certain circumstances, to kind of give them as much information as they need in order to be able to make a decision when you are no longer available to provide the answers yourselves. And then you're also going to have an alternate for just in case that the person that you picked is unable to serve in that role for any reason. And there's different reasons, right? They could have moved, their own incapacity, no longer available for whatever reasons. They could have passed themselves. And so we always want to have an alternate. And so, because today we are talking about drafting our own will, I want to be sure that you understand what the role of the executor is, which is the name of the representative who handles an estate, and you are going to be naming that person in the will. The role of the executor is to handle the estate. I said that a few times. So what does that mean? It means it's the person who's going to go hire an attorney, because you do have to have representation in probate court here in Texas. You cannot do that without an attorney. So this is the person who's going to be working with an attorney and going to apply for a probate proceeding. So going to court and saying, here's the will. We need to do what's instructed of us in this will. And they're the ones who's going to kind of handle all of that administration. And that's what it's called. It's a probate administration. So they're going to be working with the attorney that if there's a house to be sold or a house to be that the executor will serve in the role of finding the realtor, getting the house ready to be sold, and then selling the the home and dividing the proceeds of the um, of sale according to the instructions on the will. Or if the house is going to be going has a is an inheritance for someone, then that executor is going to work with the attorney to draft what is known as a distribution deed, showing that the home has been passed from the person who previously owned it to the beneficiary. So those are things you're doing with the house. It also could include things like paying debt, like we need to have someone pay the final expenses, the medical expenses, credit card debt. What if the estate was owed money? So say there's a small business and there's a judgment and there was a lawsuit and the person who passed has someone who needs to go get the money. They're the ones who are going to pursue that action in order to be able to get that. Prepare final tax returns, take care of the individual as well as do a tax return for the estate that might be needed as well. And so I think you kind of get the sense of what I'm talking about, what the executor can do. It's kind of like a job to some degree, but it's what you would do, right? Like if you were you got to pay the bills, you got to pay the mortgage, if you're planning on selling your house, it's kind of just taking care of all of those the last issues, the last matters that need to be kind of handled, dispersing the property. And so when you pick a person like that, think about that. Think about the fact that this is something that they have to be doing. And so you want to pick the person who can do that. And sometimes that's not going to be the natural choice. Right? Like it may not be your spouse. It may not be your oldest child. People who've been married a very long time, if one of them passed, they've just lost a loved one. And is that really what you want your loved one that you've been married to for 50 years having to deal with, right? And so it's like, well, maybe that's not the best choice, or an oldest child. I always joke because I'm a youngest and I can make oldest child jokes, but like, right, the oldest child may be kind of revving up to take on the mantle to be the next leader of the family, but maybe they're just really bad at filing taxes and they tend to miss, they're not really great with paperwork. Maybe that's not the best choice, right? Maybe you want to have your brother, the accountant, serve in that role because that can be a loving thing that he can do in support of the family, right? So you want to think about like who's going to be the right choice to handle the work. And not everyone wants to do that, which is why you want to have a conversation with them about what's expected and why they need to do that. Because if they don't want to do it and they're not going to be in the role, it can be a barrier. It can cause some problems with getting the will probated and then it's stuck and then we get some problems for the beneficiaries. And so you want to be sure you pick a person who is ready and able to kind of step into the role. And then you need to also have conversations with the people who you are not selecting, who are potentially the natural choice. If you have chosen not to name your oldest child as the executor and they would be expecting that, you need to go tell them, it's like, hey, honey, I know you want to do this because you love me and you think that this is the role you need to be taking. But remember, I'm not going to be here and you're going to be grieving, you're going to be sad, and there's so much work. I went to this thing and this Jesse, an attorney, said that it's going to be like 3 to 6 months, maybe even longer. It could be 2 years, depending on what's going on. You got to pay bills, you got to talk to the bank. And I just don't want you worried about that. I want you to help, your other parent and deal with that and let Uncle Bob take care of it. Uncle Bob has already agreed to do it. He knows what has to be done and he will take care of it. And that's going to be his gift to the family when I'm no longer here, right? So you want to have those kinds of conversations because when you're not here to have them, people do create stories in their mind. They'll be like, why was I not trusted? Did you not think I could handle it? And really what you've done is just made a logical administrative decision, but it still feels personal to the people around because it's still very personal um, situation that's happening. All right. Now with that, we can now move over into the drafting of the will in and of itself. So what does a will cover? I just kind of go over this briefly. I talk a lot about this in part one, so you can watch that if you want more details there. But generally, it covers only probate assets. And so what does that mean? Well, anything that's considered a non-probate asset kind of goes on its own way. So non-probate assets include retirement accounts. Those are your IRAs, 401ks, 403bs. Those you're going to designate a beneficiary. You're going to contact the financial institution where those accounts are held, and you're going to complete a beneficiary form. Life insurance proceeds, same thing. You're going to contact the life insurance carrier and you're going to complete a beneficiary document saying, hey, 50% to these people or 100% to this person. And you're going to name that beneficiary. Same thing with a payable on death account. Now, what is a payable on death account? Those are with those are your banking accounts. Those are going to be your checking, your savings account. When you can set up your account in such a way when you would go to your financial institution to do this to say, hey, I would like to have a payable on death account change my current account to a payable on death. And same thing, you're going to designate a beneficiary. This is one of the things that I always remind everyone of, that sometimes you can avoid the probate process, depending on what's going on with your estate. But many people need, the only thing they need to do to go to probate for is their bank account. And so if you have a payable on death account, you can avoid the probate process, which could be lengthy depending on the situation, and you'll be able to gain access, your beneficiaries will be able to gain access to an account immediately, maybe bypassing the probate process altogether. So the same thing, designate a beneficiary. There is a fourth type of account that you can hold, which is a joint tenancy with a right of survivorship. Now, this is for real property as well as personal property banking accounts. So just think, this is not the normal situation. In Texas, when two people purchase property together or obtain property together, they own their half or their portion. So if three people did it, they each own a third, right? They only own the portion that belongs to them. And when they pass, only their portion is passed according to the will or according to intestacy laws. That's what happens when a person passes without a will. Um, according to that, but the survivors, the other person who owns the property, doesn't automatically get that half. It's a misconception because a lot of times a couple will buy property together and that would be considered community property. And in most cases, if the person is married to if the two folks are married and all of their children are are the only children of both of them, and it's their combined children, the heir is going to be the other property owner, but that's not the case necessarily, right? So if two people bought a community property home, and there's children from a previous marriage, when the one person passes away, their children actually would inherit the property under intestacy laws, not the surviving spouse. And so it's kind of a misconception. If there is a desire to want to have the survivor, the other person who owns the property with you, to become the owner, then it needs to be converted. It needs to actually be an affirmative action. It doesn't, again, not the norm. You can convert it to a joint tenancy with a right of survivorship. I do recommend that if anyone's thinking about that, that they should probably consult an attorney to be sure that there's not some unintended consequence, some blinders that you may not be able to see around because you may not know what may be going on, that this might not be a good idea. Because once it's done, it's much harder to undo, much easier to get into, but hard to undo once it's done. So I always just say that is an option, but put an asterisk on that and really double check before you just automatically do it, that works for you. Otherwise, everything else is a probate asset. So, if your house, your furniture, your car, all of those are probate assets. And so you want to be sure that's what you're going to include. Now, that being said, on your non-probate assets, your retirement accounts, life insurance proceeds, and payable on death accounts, if there is no beneficiary listed on those, then they do become part of the estate. Then they will pass according to the terms of the will. But there's reasons on why you may want that you want the estate to actually get the funds. And that's kind of thinking your way through about what you need your estate to do. But otherwise, make sure you check those, because not if all, yeah, for most people, what they have is a house, a car, bank accounts, and personal property. And they may have life insurance, they may have retirement accounts. So with your bank accounts, your life insurance, and your retirement, if you have a beneficiary listed, well, you don't have to go through probate for those. The beneficiary would contact the financial institution, submit a birth certificate, not birth certificate, a death certificate, and then the funds will get dispersed according to the beneficiary, that information that was provided. So that's your financial things. For a house, depending on the situation, and you're going to hear me talk about that today, you may be able to transfer that home via a transfer on death deed. And so that will also pass outside of the probate process. There's a similar document for cars, which is the designation of a motor vehicle beneficiary. You can do that for your car. Even if you don't do that for your car, there is actually a way for the car to be handled after a person passes um, to the beneficiary. You take care of that, so that takes care of your car. All that's left, maybe your personal property. And frankly, you probably don't need a probate court to tell you, yes, you can sell the personal property. Like you can have a garage sale or to disperse the individual items that are owned. So kind of take that into account because all I'm going to be telling you about how to write a will today, sometimes you may be able to bypass the probate process. Now, all that being said, do not hear anything I just said to mean you do not need a will. As a lawyer, as a bad news Jesse, I will always say this. Every single person, regardless of their situation, regardless of their prior planning, should have a will. It is always better to have a will and not actually need it than to need a will and not have it. And so please hear that. And I'm going to tell you how to write your own will. So that way, if there is, you're going to realize, okay, that's not too bad. I might be able to do it. I can do it on my own. Everyone needs a will. All right. Okay. So types of wills that exist. First one is a holographic will. That's just a legal term for handwritten. It has to be 100% in your own handwriting. This is not something you can delegate. So you cannot be sitting on the couch and then tell your person sitting next to you who may have better handwriting than you, be like, okay, I want you to write my will for me. That's not how it works. It has to be 100% in your own handwriting. It needs to be signed and dated. It is optional to have two credible witnesses over the age of 14. We do recommend that they be disinterested, which means that they are not inheriting under the will. Not recommend. They need to be disinterested. So they're not going to inherit under the will. There's no benefit to them at all, regardless. Like they're just, you know, I'm just here as a friend being a witness. And then there's a self-proving affidavit, which I'm going to talk about in 1 second. The second type of will is an attested will. This one is 100% type. You're going to take out your handy dandy typewriter if you one of those, or your computer, clickety clack, you're going to type it, print it out, and that's what an attested will is. It's a typed will. It has to be 100% typed. I'm going to talk about no hybrid wills in a minute. It also needs to be signed and dated, and this one requires two witnesses over the age of 14 who are disinterested to sign the will. So handwritten will, no witnesses required, just good to have. Typed will, two witnesses, absolutely required. It's not a valid will without that. And so, and then for both of them, it is also optional to have a self-proving affidavit. Now, I'm going to tell you, you want a self-proving affidavit. What is that? So you're going to do your will, you're going to have your witnesses sign it. With the self-proving affidavit, you're going to be doing all of that in front of a notary, and the notary is going to be witnessing it, and then you're going to sign a separate affidavit that says, hey, yes, all of this was done in front of me. And what that allows, it makes the probate process significantly easier, because when you go to probate court, you have to submit the original will. And so when you submit the original will with a handwritten will, their judge is going to require two witnesses to come to court and testify that that is the person's handwriting. It can be hard to find people that way. I don't know how many people I know that's not related to me knows my handwriting. There's some people who can, but we're getting very digital nowadays, and so it can be difficult to be able to identify someone's handwriting. So that's what happens when you have a handwritten will with no witnesses. If there are witnesses to the will, which you may have for your handwritten will, but are required to have for your typed will, the court requires one of those people to come to court to testify, yes, I was there that day. I saw them sign the will. They said that was their will. That's my signature there. And they were of sound mind, and they testify to the will. So that what happens when there's a witness on the will. What does a self-proving affidavit do? It removes the requirement for the witness. So that way your executor and the attorney goes to court and says, here is the will. It is self-proved. Thank you very much for submitting that. Now let's swear you in as the executor. And so it makes the probate process significantly easier. In the document I'm going to show you, the self-proving affidavit is included. And so, but just be aware, if you're just going to take what I tell you and go write something on your own, that you can do that. Now, as we go into these documents, There is no hybrid wills. That's the law. According to what the law says and what is written in the code, there is no hybrid will, which means that there's no fill in the blank will. The documents we're going to be talking about today were, I might as well go ahead and move on to that. The documents we're going to be talking about today are pro se documents. That means self-representing. You're doing it yourself. These are fill in the blank wills that were issued by the Texas Supreme Court. So a few years ago, our state representatives in Austin directed our Supreme Court to create these wills, these simple wills that they can do themselves. On the will, it does say that you can just print it and write in the answers. I will tell you that it is highly recommended, and every attorney that I've seen that I watched that talks about this also highly recommends that you do not do that. That you actually, if you're going to use their forms to have it on your computer, type in the answers. These are fillable PDFs, is what they are. You're going to type in the answers, and then when you print it, it will be fully typed. And because that's actually what the law requires. And so I just don't like to skirt anything and the possibility that you end up with an invalid will because it wasn't clear. But we do believe that if you do have a copy of it and you write it in by hand, that it will be okay. But only these forms, which is why I don't want anyone walking away remembering that you can do that. Because if you pull something off of the internet and it's not a Texas Supreme Court approved form, then it's not going to be considered valid. So if you do a fill in the blank by hand with in a will, right? So there's four documents that the Supreme Court issued, which is for a person who is single, widowed, or divorced and who has children, a married person who has children, and a person who is single, widowed, or divorced who does not have children, and of course a married person who does not have children. I'm going to be covering how these documents kind of work together. Now, here's the important part. Can you use this form? Maybe, maybe not. Be really critical about this because while these forms may be right for you, they may not be. And you shouldn't use a form that isn't right for you if it's not going to actually work the way you need it to work because you may actually create bigger problems for your beneficiaries by having a will that's not the right fit, so to speak, than to actually just go and hire an attorney or apply for legal services to assist you with drafting the will. And so, what are the things that we need to be thinking about on why these forms do not work in your situation? Your family members and dynamics. Is there conflict? Are people disagreeing? Where do they live? Like, right? These are all going to be various things, whether to some degree whether or not what their citizenship status is, right? But so like these are things that you're going to be thinking about, right? Because depending on those dynamics, you may end up wanting to have more specific instructions in the will. If you're going to be disowning somebody, for example, you're not going to use this form for that. You're going to want to have another will because of the language that's required when you disinherit somebody from your will. And so from your inheritance, right? So there's some specific language you would need to use, and that's not going to and that's not going to be in this forms that we're providing. The type of property that's owned, right? Cars, house, stocks, like those types of things, right? That might impact what you choose to do and how it gets passed, whether they're non-probate assets versus probate assets. So you're going to want to take a look and kind of write that. But again, most people, the things that they have are house, car, personal items, and a bank accounts. Um, who's inheriting? Now, this one is a big one because you do have to take into account who's inheriting the property. It said someone living with a disability and are they receiving government benefits that are based on income. Um, Inheritances, cash inheritances, can make that individual not eligible for their benefit, right? That they're going to get. All of a sudden, they're going to get cut off, but the inheritance may not be enough to replace the lost benefit. There's things you want to do. There's things you can do to make sure that that doesn't happen, to protect that heir from losing their benefits, but while still being able to inherit the property. You just can't do it in these forms. Is there a person under a guardianship that might be inheriting the property? Things to think about. A minor under 18 years of age, again, there's some things that you may want to think about there because in terms of creating trust and whether or not what's in these forms are really what you want. So you got to just be aware, like be critical about it. It doesn't mean you can't use it, but you just want to be sure that it really is doing one of the things. Debt owed. Now, this is actually really important because if it's a secured debt, a mortgage or a car loan, if you don't pay that, they're going to foreclose or repossess the vehicle. And so you're going to want to think about that because you may want to choose one of these alternates, which is a transfer on death deed or the motor vehicle beneficiary designation. So that way the beneficiary can get access to the property quicker and then do what they need to do to be able to either sell it or change title to it. But the more important one, although it's all important, is the reverse mortgage. Everyone needs to remember that if you have a reverse mortgage, that debt is due 6 months from the date of death, not 6 months from when the probate begins or anything along that lines. And so if there is some debt owed, you again, that may impact what kind of planning that you do. But I'm also going to talk about when a TOD is a transfer on death deed is not the right thing to do when we get to that document. But that is going to be things that you're going to have to consider. Special instructions that definitely cannot go into these documents. That needs to go into the will written separately. And so what are special instructions? Special instructions include I want the house to be sold and the proceeds to be split equally among my three children. But Susie, my eldest, was really great about, replacing my roof when I needed it replaced 5 years, in 2010. And I really want her to get her money back because she paid for that out of pocket. So I want the first $10,000 of the proceeds to go to Susie and then the rest of it get divided. That's an instruction. Another type of instruction would be, if my spouse is still living at the time of my passing, I want them to be able to stay in the house until they're passing. That's a life estate. That is an instruction. Other types of instructions around life estates is that sometimes there's multi-generational families, right? And so it's like, well, the child that's currently living with me and my grandchild who's currently living with me, I want them to be able to stay in the home until my grandchildren graduate from high school because I don't want them to have to worry about moving for schools and things along that lines. That's a special instruction, right? So special instructions, you really need to be sure that that's in a will because otherwise it's not enforced. Because the only way is for your executor to be able to be instructed to know what to do. Otherwise, they're just kind of going to be guessing what needs to happen there. And they may not actually be able to make what you want to happen because the will doesn't provide for that. All right, now let's start talking about the form itself. Every form will start with section 1, which is your identification. It's going to be your full legal name. If you have an also known as, so if you use an alias, you go by a different name, you would also want to put that in there in that second line. Okay. You're going to list your spouse if there is a spouse. So the two forms for married will have 1.3 there that says who they are married to. If you are not married, those forms will not include that line. And for the children, the same thing, listing your children and whether or not they're deceased and their children, who would be the person's grandchildren. Again, if it's one of the forms with no children, that part will not be included in there. This section also declares that it's the will and that it's revoking any previous executed will. So that is how you would do that. Then section 2, this is for a married couple. There is no section. The section 2 for unmarried is different. So everything I own except for specific gifts when it involves a married couple. Your property that you own is the separate property plus your half of community property. So what is separate property? That's property that you own before the marriage. So if you have a house that you bought before the marriage, that is your separate property. It's also any property that you may have inherited during the marriage. So your parent passed away and you inherited their home. It's your separate property, even though you were married at the time of the inheritance. So that's what separate property is. What is community property? Any property that was purchased at the time of marriage. Important to know this in the state of Texas. It does not matter what the deed says. If only one person is listed on the deed when they purchased the property and they were married, it is still community property. So there has to be an affirmative process to change community property into separate property, and it can't just be done unilaterally. It can't be one spouse just going in and putting themselves as a single person and then removing the community property interest there. So that's what you own. So option one is what you see on the screen here, which is a gift to the spouse. If I'm going to give everything to my spouse, if they should survive me, if they do not survive me, then I want it to be divided equally among all my children. Okay, again, this is with children. It'll look a little different when it's without children. Um, and so that is number one. Okay, so next is option two. So option two is your spouse is not inheriting. So everything that you want is going to be given to your children. So that is option two. Does not matter if your spouse survives you, does not matter if it's community property, does not matter at all. The interest that you own at the time of your passing, which is all of your separate property plus half of your community property, will get divided equally among all your children. So this is also something really important to notice about these documents, and now you'll hear me repeat it a couple of times, which is that these documents do not create specific percentages. If you have three children and you say everything to my children, those three children are inheriting 1/3 of everything, period. So again, the special instructions, those things that what if you want someone to inherit more than that, right? Like it's like, well, Bob's going to get the car and Susie, well, that's not fair because Susie's not going to get a car. So I want her to have, you know, more like an additional $10,000 for my inheritance. That you cannot do that in these documents. It has to be, well, there's a way to work around it, but you cannot pick that. You cannot pick like section two as being like, this is everything, right? Because it don't get to be divided equally, right? So you're going to pick one or the other if you have a spouse. If everything is going to children, including the house, then you're going to skip to section four, right? So this is if ever there's no specific gift. I just talked about specific gifts. There's no specific gifts. Everything. It's everything in one umbrella. We don't care what else there is. All to the spouse. We're going to skip to section four. If all to the children, skip to section four. Now, section four is also section two. So now we're talking about, section three. So now this is where we get to specific gifts. This is everything I own except for the specific gifts. Oh, I'm so sorry. This is everything I own for the single, widowed, or divorced individuals. You're just going to list the person. So, right, you're going to write down Bob, Susie, Janet. And that's going to be, and they're each going to get 1/3 because Bob, Susie, and Janet are each getting 1/3. And so this is everything that you own. If everything is being given to these individuals, then you're going to skip to section four, right? So just to recap there, because I think I might have flubbed that up a little bit. So for those who are married, there's going to be a choice between picking your spouse. Everything goes to spouse. For those who are married with children, there will be an option of everything to my children, even if my spouse survives me. If you're picking one where you are single, widowed, or divorced, then it's going to be you just listing everybody. Section two is about everything you own. Okay. Now, section three is specific gifts. It looks the same on all the forms. These are the individual things that you want to do. So we're going to sell the home. Okay, great, right? But if you have $10,000 in the bank account, you're like, Susie fixed my roof. Susie's going to get that $10,000. So you're going to list Susie here, right? Oh, um, I'm sorry. Section three is the house. So this is the house. I am so sorry, y'all. I apologize for this. This part is for the house. If you're giving your home to somebody, you're going to list that, right? My three kids, Susie, Bob, and my grandson, Jake, is going to get the property. They're each going to inherit the specific percentage, a third of the home, right? So they're inheriting subject to the mortgages and the liens, including the reverse mortgage. And so they would have to either be able to pay for that or they're going to plan on selling the home and pay off the mortgage, right? So that's going to be that. We're going to be talking about a transfer on death deed at the end. Afterwards, just be aware, this section is talking about the house, but if you do a transfer on death deed, that takes priority over the will. So if in this document you say, I'm going to give it to Bob, Susie, and Jake, but then later on you execute a TOD that says you're going to give 100% of the house to Susie, Bob and Jake are not getting anything because the transfer on death deed has given everything to Susie. Similarly, if it's in reverse, if you did a transfer on death deed 2 years ago, giving all of the house to Susie, but then you write a will today saying, I wanted to go to Susie, Bob, and Jake, Bob and Jake are not getting the house because the transfer on death deed takes priority. So just be aware of that. If the transfer on death deed is filed, if you change your mind, you cannot change it only in the will. You need to go and revoke the transfer on death deed that has been filed. Now we're talking about personal and household items under specific gifts. So each person again will get a equal share. So this is all of it. This is not an individual grandma's favorite blanket, right? Or quilt. It's not the china. This is everything. Everything on a personal property, my furniture, my clothes, my jewelry, all of it. This is going to be shared equally for each person, right? So you're going to name Bob, Susie, and Jake there. Bob, Susie, and Jake are going to get 1/3 of all of the personal property and household items. Okay. If there is a disagreement about, like, say, Bob and Jake really want grandma's quilt, they both want grandma's quilt, it'll be up to the executor to decide who gets the quilt. Executor reserve has the has the tiebreaker there. Again, these roles that the executor is going to be the person responsible for managing the estate. And now we get to the specific property and their specific rights. So this is where you can put down, I want Susie to get $10,000. I got $10,000 in the bank account. I want Susie to get that $10,000 because she replaced my roof. You don't have to explain all of that in there, but you can. It's like $10,000, Susie. You're going to put that information. Grandma's diamond ring is supposed to always go to the first grandchild of the family. Well, that happens to be Jake. So Jake's going to get grandma's diamond ring, right? And so you're going to want to be sure that you include that. Be really careful about similar names. This is a funny joke in my family, which is not it, which is the absolute truth. Almost every man in my family is named John or James. So you can walk into a family reunion and you can say James, and half the men will turn around, and you say John, the other half will turn around. So that's a lot of similar names, right? And so if you have similar things, which does happen quite more frequently than you think, be sure you're listing which one it is, right? Like if Jake, if there's another Jake, be like, Jake, with this date of birth to make sure that we're clear on that, or Jake, daughter or son of Janet, right? Like you want to be sure that it's really clear who it is if there's similar names. Also, you want to make sure that your property description is also clear. If there happens to be two diamond rings from grandma, you might want to be sure that they know which diamond ring Jake's supposed to get and which diamond ring someone else is going to get, right? So be sure it's also specific enough that you can identify the property without you being there to say, that's the one I meant. All right. Next is the independent executor. I've already talked about this in pretty good detail when we were talking about choosing your representative, but this is the person you're going to choose at this point in time. This is where you're going to list them. The requirements for an executor is that they must be 18 years old and the court must approve them. There are things that can prevent a person from serving as an executor, so you just want to kind of keep that in mind. Uh, the law recently did change about people with felony convictions being able to serve as the executor, but there's rules about that. So if the person you want to serve as your executor is a person with a felony conviction, just double check that they can actually serve, because it can, but there's rules around that. This also section is saying that it's an independent executor. What does that mean? That means that the court's not going to supervise the executor. That means that once the person is sworn in to serve in the role of the executor, there's a couple of other document requirements that need to be submitted to the court. But other than that, they're free to work with the attorney to do what needs to be done. Okay, I need to sell the house. I'm going to go ahead and sell the house, and etc. Right? I need to disperse the household goods, a third to Bob, Susie, and Jake. Okay, Bob, Susie, and Jake come to the house and let's divvy up the house, right? Like they can do that without asking the court for permission. And so, whereas if it's a dependent administration, they may be required to go to the court and say, hey, this is what we would like to do. Can we go ahead and do that? So it's really very good. It reduces the expense of the probate in of itself and also makes things a lot easier because you're not kind of stifled by having to get all those, keep going back to court to ask for things. Only one person at a time can serve, and so you can list up to your chosen executor and then two additional choices that you can list there. But you don't have to list three. You can have just one alternate. But if you have two alternates, go ahead and do that. Right? Then this next section is just talking about the what is standard language in a will when it relates to the executor. So 4.2 is saying that they're going to serve without bond. What does that mean? A bond is an insurance policy for in practical purposes to make sure that if there is any mishandling of the estate, then the bond will cover any of that. But but this one is removing the requirement for the bond because you've chosen someone you trust. You got someone who trusts you that you know they're going to do what they need to do. They're not going to mishandle anything. And so to remove the expense of a bond, that's what 4.2 does. 4.3 is the powers given to the executor to settle the estate. That includes paying the debt, selling property, and acts that they can do without consulting the beneficiary. And then 4.4 is more standard language is that the court will not take any action except those required by law. That's furthering that independent administration language, other than the requirements that you have to do, which is recording the will, sending notice to the beneficiaries, and that inventory appraisal and illicit claims. It's that one piece of document that the executor has to file with afterwards. Okay. Section 5 is going to only be in the documents that have children. So minors generally cannot own property on their own. It does depend on the property and it depends on how old they are. So this section generally creates the custodian to care for the property until the individual turns 21. And this is standard language, standard laws in effect that says that if they're a minor, they don't get their property until they are 21. And the executor can serve in that custodial role. So guardian of the person of a minor child or incapacitated adult child. So this is also going to show up in the children documents only. This is where you're going to name the person who's going to care for the child, like actually be in custody. So the section before this one, which is custodian for under the age, that's the property. They've inherited $10,000. They got grandma's ring. Well, they're 16, and so the executor picks the custodian or serves as the custodian to hold that $10,000 in a bank account for the child. They're going to keep that diamond ring in a safety deposit box until they turn 21 years old, and then they're going to hand it over. So that's again where we are here. So the guardian of I hit the button too quickly. Sorry. Then so the guardian of the person, that's where they're going to live. Who's going to handle medical decisions if they're under 19? Who's going to enroll them in school, right? Who's going to be taking care of your children? In this case, you're going to name the first choice for the person and then your second choice. Typically, the guardian must be approved by the court. And so this is not necessarily a definitive choice, but they do take this into consideration when it's time to name a guardian. This section 7, is saying that Texas law applies and the clause for survivorship. We are in the state of Texas, and just in case anyone was unsure about that, laws in Nevada don't apply in Texas, and so it doesn't matter what's going on anywhere else in this country. If you are a person who reside in Texas and this is your place of residence, Texas law will apply when they're probating your will, because you filed the will in the state of your residence, and at the time of your passing. So it's just saying that Texas law applies. And then there's a standard survivorship clause of 30 days. So basically, if there's a beneficiary listed in this will, they have to survive 30 days in order to inherit under that will. So if, I've been talking about Bob and Susie and Jake, because Jake's going to be the child of Janet, and right, so so Janet has already passed. But what happens if Susie passed like 10 days later after the person passed, right? Well, Susie, the, by the 30-day survivorship clause, they're going to treat it like Susie didn't, Susie had already pre-passed, right? She had passed before the person. And so her portion will be handled according to what the terms of the will is, or be handed off to the, or only Bob and Jake will inherit, right? So that's basically saying the person needs to survive for 30 days. Otherwise, they're going to be treated as if though they passed away before the person who did pass. Standard is 30 days. It is highly recommended because sometimes people are together. People are together in car crashes or in car accidents, and sometimes they both can happen in a short time frame between them. And so it's just to make the probate process a lot easier as it relates to the family. Then we're going to do the execution and attestation, and then that's self-proving that I talked about. So in this case, you're going to do this in front of a notary. You're not, you can complete it beforehand, but when you print this and you're getting ready to sign, we're going to do this all in front of that. So this is the printed name. So this section, you're going to block print your name and the names of your witnesses. Okay. And again, these witnesses need to be disinterested and over the age of 14. Right? And now, in front of your witnesses and your notary, because this is a typed will, right? Remember, a typed will, you must have two witnesses. And because we're doing a self-proving affidavit here, we need our notary. So everyone's going to be able to see, everyone needs to be eyeballs looking at the same thing at the same time, and everyone needs to be aware a will's being signed. This is where you're going to sign and date it. So you as a testator are going to sign and date it. And I don't think, yeah, I did not. And then the next section is going to include the witness block and the notary block. And then they're going to go ahead and do all of that at the same time. And then you have a fully executed will. Congratulations. Something important to note that not all notaries will notarize a will. Um, so be aware of that. Don't go down to your UPS store. They're unlikely going to allow you to execute a will in their store. So you can, some banks may be willing to do it. There's other notaries that you can hire. But that being said, NRCDC, Miss Nia's organization, does help with notarizing wills when you write them yourselves, and will share that information with you in the email that she sends out. But just be aware, you can't just, don't plan like on just going to any old notary. Call and make sure that they will do it. All right, so now what do you do next with the will? Staple the will, and then do not ever, ever, ever after that unstaple it, because any damage to the will, any writing on it, any marks out, can be viewed as a destruction of the will and will void the will. So once you unstaple it, it can be viewed as a destruction of the will, and that you did not intend it to be a valid will anymore. So we do recommend that you make a copy of it before you staple it, and then after that, just make copies of the copy. And if you want to give those to anybody, you don't have to give copies to people. It's not a requirement in any way. But if you want to have a copy, that's what you can do. Now, copies by themselves are not valid, so be sure that your executor knows where you're going to end up putting this original will. It's much easier to submit an original will than a copy of the will. It is possible. I don't want to say it's impossible to probate a copy of the will. It is, but there are some witnesses requirements that can cause some difficulties. But generally they're not considered valid wills. So again, let your executor know where this will is going to be. So where should that will be? Safety deposit box? That's a good question. Some people will put it in their safety deposit box, but just keep this in mind. If your executor is not an account holder and already has a key for that safety deposit box, then they will likely need to still get a court order for them to open the box. And only the executor, with the belief that the will can be there, will be able to attend and get only the will out if there is a will. So if you want to do that, just be sure that they can get access to it without having to go to court. But it doesn't have to be. You don't have to put it in a safety deposit box. I've been asked about like putting it in a freezer. I do not like the idea of having any kind of moisture around important documents. I don't think it's necessary to put it in a place like that, but you can do what you want to do. But I just suggest that you put it in with all of your other important documents. So where do you keep your Social Security card, passports, birth certificates. That's where I would actually put them, and then let your executor know where it is. And all of those documents should be in a secured place, and then you can easily grab everything in the event of a hurricane evacuation. So, for example, and so that is kind of the recommendations I make. Then you're just going to get instructions to the executor. Again, where is the will? Tell them to not unstaple the will. But more importantly, when the time comes, which will hopefully be in many years down the line, the executor needs to take the original will to an attorney to talk about the probate process and what is needed, if anything. And so, because um, that's just what needs to happen. A lot of times people think that the will is done and they've drafted it and that's all they have to do. And no, something has to happen. And so, so be sure that the executor is aware that something has to happen, and that's something from their point of view at this moment is to go talk to an attorney about the estate with the will in hand, so that way they can have a conversation and be accurately advised on what the appropriate next steps would be. Okay. I did not mention about filing the will. The will does not have to be filed. For some people, they may choose to do a recording. They'll send it to the county clerk where they reside, and then it will be considered a true copy of the will. And but that's not necessary. If you do choose to do that, the will is not public record. It's not available to anybody. But it is a possibility, but not required to do so. You don't have to mail it to yourself. I've seen people talk about like, oh, you need to sign the envelope or something. None of that. You don't have to do any of that. The requirements I've already mentioned. You're just going to complete the form. You're going to sign it in front of a notary, and you're going to just put it into a safe space. So, okay. Now let's talk about the transfer on death deed. So, a transfer on death deed is commonly known as a TOD. It's a way to transfer real property, talking about land and a house, to someone else when the homeowner dies. It's when it takes effect, is when the person passes. As I already mentioned, it avoids the probate process. Because the deed is on record, the only thing that needs to be done is a recording of the death, and then the TOD will go into effect. And as a result, it avoids probate. Very useful solution for people where it works best for them. Again, it takes priority over will. Just as a reminder, it does not matter when you write that will, doesn't matter at all. If there's a transfer on death deed on file, it's going to control over the will. If you have a will that you would prefer to have the rules of the instructions in the will, then you have to file a revocation of the transfer on death deed. You still own the property. You can do whatever you want with it. The beneficiaries don't have any interest in it. So they can't go down and say, hey, I'm a beneficiary of this property. I would like to get a home equity loan on it. They can't do that. So you can do whatever you need. You can sell it, you can mortgage it, you can do some repairs, you can whatever you need to do. It's still your home. On transfer on death deed, you are passing only the portion that you own, right? So if you're a community property, it's 50%. If you are a joint owner, then it's your applicable percentage, right? So, Bob, Susie, and Jake had an area at home. They each have a third. And then Susie decides, you know what? I really want to do a transfer on death deed for this home. And now her one third is what passes to her beneficiary under the TOD. Bob and Jake's shares, their individual one third, is still theirs. Okay. Again, the property is inherited subject to any debt, so the heirs will need to be able to pay the mortgage and or obtain financing to pay off the mortgage, and or they will be selling the home in order to cover that. If there's a reverse mortgage, they only have 6 months to make those arrangements. Okay, so what is the pro se TOD document? This one is, oh, I just realized I don't think I talked about it. But the same thing goes for this, has for thinking about whether or not the will is the right thing. But for TOD, you want to be sure it is the right thing. All those things I talk about, like special instructions, beneficiaries that are inheriting the property, you want someone to get a third and someone to get two thirds. All of that you're not going to be able to do in a transfer on death deed using the pro se forms. So that you may want to consider talking to an attorney about, to make sure that we do it the right way. Because sometimes what you want is better to be handled by a will than by a transfer on death deed, because we're going to want to be looking at the goal. What's the goal of the inheritance? Like, where do we ultimately want it to be? What are we trying to accomplish? And sometimes it's just better in a will than it is in a TOD. And so, but you're going to see how the TOD is written, and you're going to see what my recommendations are as I kind of talk about that as we go. All right, so the form is a fill in the blank form. That one can be fill in the blank. That one does not require you to type it on the screen, but obviously it's going to be a fillable form, so you can type it, but it's not required to be. So there's also a form available at this website called texas.tylertech.cloud, and you see that that's where you can go in and type it in, and you type in the information, and it prints you out a transfer on death deed that has everything filled in. Right. This is the form. Section 1, I will tell you right now, my apologies. The way that the form is written in order to answer some of these questions gets very confusing. I will do my best to walk through it so that way you know what I'm talking about in each section. Be aware that there will be a recording available, so don't think of this as one and done. If you are going to do your own transfer on death deed, come back and watch the recording to be sure that you are completing it correctly, because this can get confusing. Section 1 is the property owners. Who are the owners? You're going to list yourself, and if there's a co-owner, who the other co-owner is, right? Your spouse, your sibling that you inherit that with. Added pages if you need to add pages. That one's easy. Okay. Section 2 is your legal description of the property. This one is actually probably the most difficult thing to do. Ms. Dee and I were talking about this before we did this, but when we host a TOD clinic, we have a person there from the county records to help search for the property record information to make sure that the legal description is correct. And so this is not what's on your property tax returns. A lot of times there is some form of a legal description there, but it's usually shortened in order to fit the space. But these are going to be the things like meets and bounds, and from this latitude to that latitude, in the Bob Hope subdivision. So it can be a little bit more, it's a more complicated description, and you want to be sure that you do that. But otherwise, the best way to find it is on your own deed. So when you purchase the property, you should have a copy of your warranty deed of that. And on that warranty deed is going to be the legal description of the property. And so that's what you're going to type into that section. Okay. It's not your mailing address. It's not the physical address. Now, number 3 is the address of the property. And that's where you're going to put down 123 A Street, Houston, Texas. And so that's where you're going to put what it's commonly known as, typically the physical mailing address. All right. Now, this is where it starts to get confusing. There are 3 sections. There are 3 big sections. There's going to be an A, a B, and a C. You're only completing one of those. You're only completing an A, a B, or a C. So A is when both spouses own the property and they want to leave it to the surviving spouse. So, let's not make Bob and Susie because they're obviously siblings. So Susie and her husband Jim. So Susie and Jim own this property. They're going to, so both spouses, and they wanted to go to the surviving spouse. That's all it has. That's what it says. So by checking that box, you're saying, okay, Susie wants it to go to Jim. And that's how it's going to be. The alternate beneficiaries only come into play if both Susie and Jim have passed. So as long as one survives, the other will be the owner of the property. But if they both do not survive, then it's going to go to their named beneficiary here. This can be their children, it can be a cousin, it can be their best friend. It does that's this so this can be anybody listed there. And so you're going to name them there. You can have more than 2, but then they will be inheriting their percentage, right? If you have 4 people, then 4 people will own a quarter of the property if both of them have predeceased. Okay. So that is the situation there. Okay. This is where I'm going to talk first about multiple inheritances. Sometimes you got to think about whether or not the TOD works, not because is good for you as the testator passing the home on, but whether or not the beneficiaries are going to be able to do what they need to do. If more than one person inherits the property, there can be conflict. What if one person wants to buy the house or sell the house and the other person wants to live in the house? Those are things that they're going to have to figure out amongst themselves, and that can create conflict between them. If you believe that they're not going to be able to do that on their own, come to a conclusion, an agreement on their own, it may be better to put this into a will where the executor will have some mediative ability to be able to negotiate between them and then ultimately make a final decision if they are not able to come to an agreement. So that's going to apply for any time we talk about more than one person inheriting the property under a TOD. If you think that they're not going to be able to come to consensus on whatever it is that needs to be done next with that property, then you should put the house into the will and make whatever instructions that you want to have in there so that way we can minimize the potential conflict and that can fracture a family being real. After the fact. Okay. So picking A, if you are married and you want your spouse to inherit the home. Now we're going to go to B. Only one spouse owns the property. So now we're talking about separate property. So Susie owned the home before she married Jim, and Jim has now moved into the property, right? So in this case, we can name the primary beneficiary. I designate my spouse as my primary beneficiary. So this would be Susie naming Jim has the beneficiary here. And then if Jim passes before Susie, then the alternates come into play here. Then that's where it's going to be, whoever the alternates are. So the primary beneficiary is still the spouse, and the alternate beneficiaries only come into effect when if Jim predeceased Susie. After that, if the spouse survives, so if Jim survives and he has now inherited Susie's separate property, he gets to do whatever he wants with that. So if Susie had children from a previous relationship that she was like, hey, Jim, I want you to be able to live in the house as long as you want, but when you pass, I really wanted to go to my kids. Section B is not what you pick. No B. Because B, if Jim survives and he takes the property, we're just relying on Jim's good word that the kids are going to get it. The alternates do not come into play here. So you will not pick B if if you want something else happen. Now, if Jim is the parent of both kids, and we assume that Jim would also want the shared home to go to both kids, then no big deal, right? But you got to be careful about that. That again is not what you would pick. You can still do a TOD, but you would not pick B. All right. Now for both A and B, so this is going to be, so A is going to have a number 3, B is going to have a number 3. But they look exactly the same. So this is going to be what happens beyond the alternate beneficiary, right? Um, so right here you can see the number 2, you're naming the beneficiary, the alternate beneficiary. So in both of them, alternate beneficiaries only come into play when both spouses have passed, right? So remember that. So A, both spouses have passed, alternate beneficiaries are inheriting the property. In B, if Jim predeceases Susie, alternate beneficiaries are inheriting the property. So in this case, both of the couple have passed. And so now we're looking at what happens with the alternate beneficiaries. So and this is a choice, you're going to choose what's going to happen here, right? So if the alternate beneficiary is a child or a sibling, then you need to complete number 3. So section A is that if one of the children should pass, what happens to their share, right? And that would be that the deceased alternate beneficiary will go to their children, right? So that would be Susie's grandchildren if something should happen to one of her children, right? So that we would be picking A. You want that to go that way. B is no one else, right? So Susie has passed, her child has passed, who's the alternate beneficiary. Then we're going to pick no beneficiary. It's going to be canceled. Okay. I, I know it gets complicated. All right. So now we get to C. C is everything else. If A does not apply, you both of you own the property together and you know as a married couple, you're not a married couple owning property together. That's A. B, you're not owning a property, has a single homeowner and you don't want it to go to your spouse. B doesn't apply. C is everything else. C is what many people will pick. So you're gonna pick C. Um, this is where a spouse is not the primary beneficiary, right? So A and B, the spouse is the primary beneficiary, and only the alternates come into play. So C is what you would use, but what Susie would use if she wanted her home, her portion of her home to go to her children and not to Jim. She's going to pick C. So even though she's married, she's going to pick C because she wants her children to be the primary beneficiaries. And so then you're going to list the names of the primary beneficiaries. You're going to list the names of the alternate beneficiaries, just like the first one, right? So think of it this way, right? C is when you're not naming your spouse, you're naming your children. You're going to put the children as A. They're just, you're substituting your children for your spouse. And then alternate beneficiaries in the event that both beneficiaries do not survive, then it will go to the alternate. Okay. So now, oops, we're going to the next part. Under C, there's an A, B, and C. You must complete the A, B, and C under C. So, right. So the first set of A, B, and C, you're picking one. You're picking an A, B, or a C. If you pick A or B, you're going to go all the way to the end of the form. You're going to skip all of this because A and B, everything's in there. But if you pick C, you're going to now do an A, B, and C. So in each one of these, you're going to want to pick one, right? So this is basically a way to try to prevent a probate problem. It's trying to prevent that we don't know where the house goes, who's going to own what. That's what all of this is. So just think of it that way. It's if this, then that. If this person has passed, then I want the property to go this way. And that is essentially what it is. So A, if you have more than one primary beneficiary listed, so Susie has two kids, which I've not named. So kid one, kid two, right? So Susie has two kids, and kid one passes away, but kid two survives, right? What do we want to happen here? A is that the property that would have gone to kid one now goes to grandchildren one. So that's A. B is no one else. That means that the entire property goes to kid two. Grandkid one does not inherit the property. Okay. So that's A. You got to pick one, right? And so for B is what happens if both kid one and kid two unfortunately have passed before Susie has. And so now we have grandchildren. What do we want to do here? This can get confusing, so follow me. The options are to go to the alternate beneficiary. So let's go back to this section. So you had one and two, then you listed alternate beneficiary. So kid one, kid two, and then, alt one, alt two. So that's completing alt two. That's section two. Under B, we have the option to do one of two things. A is, hey, kid one and kid two have predeceased me, but they both have grandchildren. Grandchildren one, grandchildren two, and three. Those children are going to inherit their parts. So kid one had grandchild one is going to inherit half the property. Kid two had grandchild two and three. Grandchild two and three inherit a half of the property. All right, so that'd be a quarter each. And so that is what A is. It's like send it to their children. That's what we want. Their heirs, according to their will, their children, right? That's how it's going to be. Or section B there is that you wanted to go to the alternate beneficiary, right? So both kid one and kid two have passed. Now it's going to alt one and alt two, not grandchildren one, two, and three. Okay, so that's you're going to pick one of those two. And then section 3 is what happens if an alternate beneficiary does not survive, right? So now we have Primary one and two, kid one and two have not survived. Alt one and alt two have not, alt one or alt two has not survived. Now, what do we want to do with that? It's the exact same thing as B. A is all right. Well, since alt one and alt two, one of them has not survived, it's now going to go to alt grandkid one. Their portion is going to go alt grandkid one, or it's going to go to alt grandkid two, right? Like, so that's going to happen. Or no one else. If the alternate beneficiaries have passed, so now everyone, so now there's no one, right? Kid one and kid two has passed. They don't have grandchildren, or the alt one and two were the heirs, even though the grandchildren are there, right? So then alt one and alt two has also passed. Now what do you want to happen? Which is no one else. They don't want anything to go to anyone else, and the deed is canceled. And now the house will pass according to the will, right? So once we get to that unfortunate situation where no one has survived, it is now going to pass according to the will. And that is a reason why you need a will, right? Better than have a will and not need it than need a will and not have it, because now you can have a very complicated probate because the transfer on death deed has been canceled because of the lack of survivors. And now it's going to go to who is named as the beneficiaries of the residuary estate under the will. Okay. All right. No questions have popped up yet. So, all right, and that's it. You're gonna sign it, and then you're gonna do what you need to do next. Once you complete all of that, and you've watched this video like 4 times, make sure that you completed each section well. Just read it. The instructions are on the document. Just read the instructions. You can see how much that I really kind of had to think about how to do that. So take your time. If if you do your own thing, there may be like a legal advice clinic you can go to where they can maybe look at it, make sure it's correct. Hopefully we may be hosting a TODD clinic where you can come and do that. But like it can be complicated, and you don't want to do it incorrectly because you can't correct it once you're not here to correct it. And so, but once you're done and it's completed the way you want it to be completed, with a notary present, you're going to sign the TODD with the co-owner if applicable, because this can be a joint document. The notary will sign and put the notary seal on top of that, and then you must record it. What does that mean? You must file it. It doesn't do any good. Do not take it and just stick it into the drawer. You must actually get it to the county clerk where the property is located for it to be effective. There is a cost for it in Harris County, which is where I am. It's going to be about $36. But it does depend on the county. Each county has their own fee schedule and how much they would charge. And then once it's recorded, the clerk will return that to you. You're going to put that in with your will and your other events planning documents. Keep it in a safe place and let the relevant people know where it is. And then again, as a reminder, if you change your mind, you must file a new TODD or a revocation if you want the will to govern for the property. Okay. The good news is that we are pretty much done with the two hard things, and now I'm going to talk about the other forms. So the other forms are easy. That's the good news. I'm going to spend almost no time talking about it because the ones on the left under statutory form, they're already written for you. The folks in Austin have put it into the code, and they have passed the law and into the code on what these documents have to say. And so you don't actually need to do very much on it other than to check off the box of what you want to be done in them. The statutory durable power of attorney is the document that you would complete in the event of incapacity to make financial and legal decisions. So you're going to look at the form. It's going to show you all the powers that the person will have. You're going to initial, cross out, or give all of the powers to that person, and then you're going to sign it with a notary, and then that will be it. You get to choose if you want it effective immediately or only upon incapacity. There's no right or wrong there, but it's all laid out for you. You don't have to write anything else in there. You don't have to go figure out what it needs to say or anything. So a medical power of attorney is what that sounds like. In the event of your incapacity, that's the person you have named to be able to make medical decisions on your behalf. Same thing. If it's already written out, all you gotta do is just write in the names and sign and date it with a notary, and then that will be executed and complete. The advance directive to physicians, it's commonly known as a living will. These are end of life decision making in the event of a irreversible illness as well as a terminal illness. It's kind of letting you know, it's making your wishes known on whether or not you would like life-sustaining treatment or if you would like to be able to be passed peacefully. That is also a statutory form. It's already outlined, and you just have to decide what you want for each one. And then a declaration for mental health treatment. These are for individuals who are at risk for psychiatric hospitalization, and this will provide the instructions of what they want as it relates to emergency treatment, medication, isolation, treatment along that lines. And that again is also statutory. Now, I go into more detail about what each of these documents mean and what you need to be thinking about when you're executing those documents with in section 1. So if you're not sure, you're like, oh my gosh, Jesse, you just told me all of that in like a minute. That's too much. I, I have more questions about that. Please go watch part 1 because I do spend more time talking about that. Since today is about drafting, we don't really go through that because the forms are already written. Miss Nia is going to send you copies of those templates for you to be able to see what they look like. There are some additional documents that are not statutory forms, but they are extremely simple. A declaration for a guardian in the event of later incapacity. That's in the event you become permanently incapacitated and a determination has been made that you need a guardian to take care of your not only yourself, the person, physical care, but also of the estate, which is the financial and legal affairs of the war of the person who has lost capacity. That's naming the person that you want. It's a super simple form. HIPAA release. This is not what you complete with your doctors when you go check in with your doctor. This is a general HIPAA release, so that way your medical power of attorney and your guardian can obtain medical information from providers across the board. It's a generic one. Again, that's also standard language, and there's nothing you have to do about it other than naming the people that you want to be able to get that information. A supported decision making document. They're again pretty simple. This is a good document for people who have diminished capacity. That basically means that they need some support. They may not be able to make some decisions on themselves, or they need some help making decisions. But and it's useful for children who age up that again may need some support, but also for those of us who are aging where we may get some diminished capacity due to age. But again, that's also a very simple form, pretty standard language, and all it is just naming the person. And otherwise, the language is pretty standard. And so that is it. I can't believe I'm done at 2:30. As a reminder, this may feel overwhelming. And you're like, oh my goodness, Jesse, is that really all I need to do? That seems complicated and more difficult than I would like. Um, hey, you can ask for help. In addition to, I'm Lone Star Legal Aid, so that's my information that's up there. Love it if you need my help to come and talk to me. But my friends and colleagues at Earl Carl and Houston Volunteer Lawyers are also pretty darn spectacular. So I won't take it too personally, but just know that assistance is available to you. And it doesn't hurt. All it takes, if you believe there's a possibility that you qualify for services, it only takes the time it takes to complete the application. And if you're not eligible, then you know what to go on and do next. But if you are eligible, then we are able to find you an attorney to help you draft these documents. And so just kind of consider that as you um, decide how to do moving forward. And Nia's going to include all of that information in her email. I realized I didn't have a slide with all of their contact information on there as well. Alternatively, if you don't qualify for services and you do want to hire an attorney to help you with these, which again, I'm a lawyer. I'm going to say do it. You know, it's always good to have someone who's outside of it to be able to look at it in an objective way and be like, hey, this is what I really think you need to do, and have the experience to look around corners that you may not know about, because that's what lawyers do. We're like bad news preventive people, you know, to kind of consider that. But we also can recommend that you contact the Houston Lawyer Referral Service, and they can give you the names of a couple of private attorneys that may be able to assist. Sorry, my dogs have decided to have a little mini riot. I always like to end with a little silly, because this is a heavy topic, and even though you are here because you know you need a will, doesn't mean that it's fun to talk to, talk about. So this is my comic for today, which is we're standing over our elderly parent here, and here he says, "Who cares about where he buried the gold? It's his passwords and other digital assets we need." And so I am here to answer any questions that you have, and so feel free to unmic yourself, or mute yourself, or if you prefer to type it into the chat, let's do it. Back to you, Nia.
All right, cool beans. There were only two questions that were emailed to me in advance. Let's see here. One is, and I'm going to get to that, and then I'm going to run back to the chat, but I didn't want to forget about this.
Mhm.
The need for married couples to have separate wills. Can you explain?
Yes, for sure. Each person should have their own will. And because it is your own, because although it may feel like everything's owned together, it's not. And you may have a different wish from your spouse, right? So if people are married and they have children from a previous relationship, you're going to want to do a will that's going to be different from your spouse that is not their child, right? Like that's not their children, potentially. I don't know. It's your own wills, do what you want. But yes, but so they each have their own needs and differences that they need to go at. And even if they're going to be what are called mirror wills, where the children are the children of the marriage, and it's like everything to my spouse, but all if the event that she passes or he passes to my children and they're mirror, you still need separate wills because you can't, because when one passes away, you still have to do something. And so you don't want another person doing that. Also, we're talking about a joint will, like both at the same time, highly, highly disfavored. There are some attorneys that would argue that they're not even considered valid wills. Those are very disfavored, unrecommended, because when one passes away, then you cannot change it. And that is not necessarily a good thing because when one passes away, it's a good time to look at the will of the surviving spouse to see if anything needs to change, right? And because maybe there is new property, maybe there's grandchildren that were not considered at the time when the original wills were written, and now you can't change anything. It's stuck, and it can be a hindrance, and for potentially decades, right? Depending on how long it's been. So people, even if you want the same thing and it's going to be a mirror will, you should still each both have your own wills.
Okay. The other question was about wills versus trust. That seems to be the biggest question that we get from a lot of people.
Yeah. So I do talk about that in part one, probably a little more deeply, but I'm going to do my best to kind of give you all the information as I can here. So the thing about trust is that you may need one, you may not need one. I am not antitrust. However, I am antitrust if the only reason why you are doing it is to avoid probate, because that's usually the reason why people say they want to trust. Here's the thing. We are in Texas and the Texas law applies to us. If you're listening to national experts like on one of the morning shows, or you somehow ended up on the law side of TikTok or something, right? You don't, one, you may not know what state they're in. They may not tell you what state they're in, but they're talking about things generally, right? So usually you'll hear a financial expert say, I will never write a will. I'm going to create a trust because then I can avoid probate. Probate in Texas is actually not bad. If you actually remember what I just talked about, right? This will that I just went through, pretty basic will, is that we said that the executor is going to be independent, doesn't have to talk to the court about anything. There's going to be no bond. There has to be one court appearance, which takes like 10 minutes. The longest amount of time is waiting for everyone else to finish their part, right? If you're the first in the line on that hour, you're done in like 10 minutes. And then there's one piece of paper one document that you have to file. Everything else is outside of the court process. Guess what? You still have to do all of that for the trust. Like it doesn't negate the work that still needs to be done. You still have to do a deed of the home into the trust. You still have to do that. You still have to create something for minor children, like what's going to happen at that. And oh, and by the way, even if you do create a trust, you still need a will to put whatever you have that may not have already been transferred into the trust to transfer into the trust. So, and so so that's why it's like if the only purpose is to bypass the probate process, you may not achieve that even with a trust. So, probate in Texas is pretty simple and a well drafted, properly executed will. A trust is useful in the right situation. So the question you have to ask yourself is, why do I need a trust? If it's just to avoid probate, that may not be a good enough reason. Other reasons why you may need a trust is that you need to make sure that someone is inheriting the property, that may have benefits be affected. They may be under a guardianship, and so you might as well go ahead and put it in a trust. Tax planning. A lot of times, sometimes you're going to do tax planning if you have a taxable estate. You may want to consider doing it into a trust. So there are reasons for that, but it's not necessarily going to be because I just wanted it to be easy. And by the way, creating a trust actually may be more expensive than the cost of writing the will and doing the very simple probate that may be possible. So, so that's kind of the distinctions. I will not say, don't, please don't mistake. Some financial experts are talking about very real things. In Texas, estate planning is a will. That's not the same in other states. For other states, it is a trust. That is what you do because they are complicated probates, just not in Texas.
Okay. Wanted to make sure that that got put out there.
Yeah,
Uh,
no, I understand. It is the most common question.
can we revoke or cancel a TOD?
hmm Yes, 100%. If you change your mind, you can definitely change it. If you want to, you can do a revocation. You just file a revocation in the county court where the TOD is filed. If you want to have a new person, you would just file a new TOD. The subsequent TOD automatically voids out the old TOD. So you don't have to do both. Some people will do both. You can do a revocation and a new TOD at the same time. That's fine if you want to make sure like there's a dot there, that there's no confusion. So that's what you can do. If you sell the home, the new warranty deed that's filed will automatically cancel the TOD because obviously at the time of passing, no one owns the person doesn't own the property anymore. So you don't have to file a revocation if you sell the property. But yes, anytime you can change your mind anytime.
And I think that's a misconception too, that we should probably reiterate that doing the transfer on death deed, it doesn't change your ownership or your
Mhm.
interest or your ability to do whatever it is that you want to do to your property. It's still yours. Nothing happens to it. So,
Yeah.
so do note that. I've heard a lot of people they they even when they talk about the difference between the Lady Bird and the transfer on death, that they think that they're giving up their house or that they're
Mhm.
no
Right.
longer the owners, and that's not the case.
Right.
So.
Even in a ladybird, that one is the one that gets real because it's a retained life estate that people think, oh, well, I no longer own it. And that's not true. As long as you have capacity, you can still sell your home under a lady with the ladybird deed on it.
Yeah, and then also with the trust too, that I've in our last presentation, a lady came up and said that it was a trust form that she had bought online and she had filed it and did whatever. I'm like, oh my God. I said, you really need to talk to a lawyer. Please talk to a lawyer to make sure that you didn't mess up something. And then she was a much older lady, and I'm like, you could potentially screw up all of your homestead exemption
Hmm.
because
Yeah.
you know have now transferred your property into this, and oh, it's a lot. It was a
Yeah,
lot.
I
So
I
definitely.
agree with that, and I really want to emphasize that if a trust is the right thing for you, please do not do it on your own. There can be so much unintended consequences around creating a trust if it's the right thing for you to do, and so and sometimes depending on what you do, may be very difficult to undo. But yeah, transferring a home into a trust can trigger a lot of tax problems, property tax exemption problems if it's not done correctly. And it is nuanced rules. It's not like you can just be like, oh, I'm gonna find a will some or trust somewhere online. Because also, how are you vetting that that's a good document? I don't want to. I'm not saying that all online sources are good or bad, right? I don't know. I haven't checked all of them. My concern as an attorney is that you are not an attorney looking at it and you're relying on whatever the software has made a determination is the right thing for you. And if you don't have some knowledge, you might accidentally do something wrong. Now, I'm not saying you can't, but I would just always be like, just be cautious if you're going to do it without an attorney. Be super cautious. I would actually recommend against it.
And then I think it was an irrevocable trust that she did,
Oh
the
no,
one she
yeah,
had formed. So talk to an attorney when it comes
yeah.
to
Talk to
trust.
an
That's
attorney.
all. That's all.
Especially the word irrevocable is anywhere on there. Do not sign something and file any. Right, right, yeah.
That was those were the only questions that were in the chat and that were emailed to me. I don't see anything on the social media uh, page, but I did have a question when you brought up the distribution deed that needs to be done by an attorney. So once property or whatever is divided up, that step that because I've seen some people think that they have a will, somebody passes, they think that they automatically just transfer everything over, because sometimes some of those attorneys don't do that additional step. What is it that people need to ensure that that additional step to make sure that that property actually transfers, and
Mhm.
that a new deed is actually produced or something is attached to it to make sure that that ownership is transitioned? What do they need to know about that?
So if the home is being so it starts getting into what's happening in the probate process a little bit there, right? Like, so if the executor is planning on selling the house, a distribution deed isn't necessary, right? Because the house is going to get sold under the administration. There'll be a new warranty deed, right? And that would be transferred because the estate will be selling the home. It's when the person is going to be actually inheriting the property. The recommendation is that you could do a distribution deed that's filed in the real county records. The will be there. There, it is part of the county records as well as what it says who owns the property, but putting the distribution deed in place and actually filing it just puts that clear dot there, right? It makes it clear that when someone is looking in the property records and title companies are looking in the property records, it's absolutely clear that who owns the property and how it was passed. Even more important than that, if the family actually decided to do something different than what's in the will. And so hate to break the news to people, your beneficiaries can kind of change things on their own, right? Like, because like if like Bob and Susie and Jake inherited a home together, and then Bob and Jake are like, we have our own homes, like, right? Like, we got our own homes. It's fine, Susie. You get the property 100%. We're cool with that, right? But then there's no documentation that says that. Like, there isn't a distribution deed that says based on family settlement, or there's one distribution deed to all three, and then there's gift deeds conveying their interest. Like, there's different ways you can do it. Now, if all we have is the will and that's the only thing on record, Susie has a cloudy title because, and when she wants to sell the home 20 years from now, and Bob and Jake are have moved to Europe because they won a lottery or something, right? She's not going to be able to do that because the records are not clear. And so the expectation of relying just on the will has the demonstration of who owns the property is something that you know, may or may not necessarily be a good thing. Now, you can admit a will has a minimum of title only, and that order is what says it. That's what, and the distribution deed may not be needed at that point. So it does kind of depend, which is why you have to have an attorney, right? When they talk about like you can't represent yourself, but it is for the attorney to kind of look at the situation and be like, yes, this is the documents that we need to file to be able to make sure that you have clear title.
Okay. And speaking of clear title, that's the next part that's coming up. So next Thursday is the inherited property and clearing title and other probate concerns. What happens after someone passes is going to be covered in next Thursday's presentation, and that's online via Zoom at 1 p.m. As well. The fact that it's been over, almost 2 hours now for just this presentation, and then the other presentation that you do, which we again we had to divide into two parts. The first part, she goes into very extensive detail about each of those individual documents and the execution and what needs to be notarized and all that, and why do you need each of those. That's done in part one. Part two was this, strictly about the wills and the transfer on death deed. The reason being that we had to split that up is because it's too much information to go into that much detail in that short period of time. As you can see, again, 2 hours we spent talking about the wills and the transfer on death deed mostly. So to get into the extensive detail of all those other documents as well, and why do you need each of them, it's a lot of information, and your head would be spinning completely if we had to sit there and go over that much detail in one presentation. It's too much. So next week's we're going to get into the inherited property, what happens after your loved one passes, with a will, without a will, when you've got multiple heirs, and what needs to be done, the whole probate process itself. So if you do have any of those types of questions, definitely attend the session next week. But this is more like the preemptive side of things, what you need to do in advance, what you need to do to properly plan and prepare. And I try to tell people that, one of the best gifts that you can do for your family or for your heirs is to make sure that they have this kind of stuff put in place already, because there's nothing worse than trying to have, go through a grieving process and handle affairs of somebody at the same time while you're trying to grieve and nothing's been done. That is the most stressful, time consuming, you know, mentally taxing thing that you can actually do in a situation like that. So we're asking people, and pay it forward too. Let your neighbors, let your your own heirs, your kids, or whomever know that this is the kind of stuff that we need to get out there and get distributed to the community. Not necessarily you being the advocates to say this is how you do it and how you fill it out, but this is the information you need and this is where you can go to get the help or get the information to explain it. Please don't listen to the street committee. I call them the street committee because people, all those different social media sites and people that are out there, those law and order experts, that watch the CSI shows that think that they know everything about the law because they've seen it on TV. Yeah, it's not accurate. Just please make sure that you're getting accurate information from a reliable resource, professionals in those fields that can provide you with the right information as it relates to Texas law in your particular situation. So I just wanted to stress that importance. Are there any other question from any other participants that we have that are joining? Because I don't see anything else in the chat. Speak now or forever hold your peace. That's what I want. But it was a lot of information, Jesse. Thank you so very much. Um, thank you. Quite informative. You are very welcome, and I hope you all got the information that you needed to come for today. I will also include your presentation that you did last month, Jesse. The recording of the Wills and Advanced Legal Planning Part 1. Why do you need it? It's got all those other details. A copy of those templates and things like that will be attached to that so that you can go back and watch it. If you want to watch the live presentation, the next month we will be having the live presentation with Miss Jessie and all of the other things that are talked about in the recording. So again, we ask that you pay it forward. Please, share this information with your loved ones and anybody else that you also know that could find this information to be beneficial. At the following the end of this one, there was going to be a link, a survey link that pops up on your screen. We ask that everybody just takes a couple of minutes to fill that out for us and let us know, give us your feedback, let us know if there are other topics that we don't currently offer that you may be interested in. If there's something pertinent that's going on in your particular community and your family that you want more information about, please let us know as we're planning future presentations. That we'll definitely keep that in mind to know what people are actually going through and what they want more information about, so that we can try to schedule that for you as well. But if you guys have a testimony that you'd like to share or information or how you found this information to be beneficial, we're asking for you all to share that with us as well. Because otherwise, if we don't get the feedback from you guys, we don't know if what we're providing for you is still vital to you, and is it impactful for you, is that the information that you want. So we want to continue to do what we're here to do, or what we think we're doing, so that you all can get the most information that we can possibly provide for you. So again, we want to thank you all very much for joining us. I will be sending out the emails, the templates, links to all of the different resources, the other services for our other legal service providers and partners. All of their information will be included on the email as well, and along with the link of the recording for this presentation and the previous one, and the calendar and the link for you to go to register for next week's presentation if you all are interested in that. With that being said, what else do we got coming up? Yep, that's all we've got for next week. Later in the month, we've got our we are having a mind over matter, how money shapes your mental wellness. Look for more information to come out about that. That's going to be on Thursday, the 18th. We have our property tax and exemptions and payment options workshops, property tax foreclosure, and a voter registration, new laws and processes presentation that's going to be up this month. But all of that's going to be included on the calendar that we send out to you guys so that you can get more information about that. So, all right, Jesse, is that it? Is there anything else? All right. Well, thank y'all very much for joining us. We hope that you all come back and see us again. We hope again all the information was beneficial to you. You all take care of yourselves. You stay safe, and we will see y'all next time. Hey, Miss Tina, I see you up there.
Thanks, everyone.
All right, thank you. Hey, Miss Linda.
Hey Nia, I couldn't get in the chat, so
Oh, did you have a question?
no, I was just trying
Oh,
to get
okay.
back to you when you said hello.
Okay,
I
all
was in
right.
all ears, and thank you so much. It was great.
Okay, good deal. Thank you. Glad you enjoyed it.
Yeah.
All right, y'all have a good one.
Okay, thanks. Bye-bye.
Bye.